NCAA lawsuits and settlements are always in the news, so we're back on the big mountain to break it down for you.
Hey, it's great to have you back here on the mountain. We welcome you to a very special episode. We have Kevin Gold on with us here again. We had him several months back talking NIL, and he was so kind to say, yes, he'd love to come back on and talk a little bit more about the House and NCAA lawsuit settlement. So before we actually get into any of this, I'm going to kick it to Kevin. Just let him tell you all a little bit about himself, and then we'll get right into it.
Sure. Thanks, guys. It's great to be back and on camera this time. But my background, so I'm an attorney, kind of boring, but relevant for today's discussion because you almost need to be a lawyer to follow all the things that we're talking about. So I'm a lawyer by day at a law firm in Harrisburg, PA called Pillarot. More interesting, though, is that as part of my law practice, I represent NFL players, and I've been representing NFL players for about literally 30 years. So done about 120 NFL contracts for about 30 different NFL guys. So, in the NFL world, I'm an NFL contract advisor. But because I recruit athletes on a yearly basis, I've had to become familiar and very exposed to the NIL world. And because if you're recruiting an athlete nowadays, it's not just all the things you can do once they get to the NFL. They want to see, okay, can you help me get NIL deals while I'm in college? So a lot of what being an agent is now and getting clients is focusing on that name, image, and likeness and that aspect of college athletics.
Awesome. That's great. And that was really the first time we had Kevin on was to talk NIL and kind of how does it work? What are the ongoings with that? You can check that out on our channel. I'll try to link that at the end of this episode as well. Really interesting stuff that really still holds water today, even after this settlement. And that's where what we want to talk about here today on this episode, kind of diving into the House settlement, not so much the details necessarily, although I'm sure, Kevin will have to talk a little bit about that, but more so, how does that play moving forward? What does this mean for schools and for athletes and for the NCAA and all that kind of jazz? So real quick, let's just I'm going to lay a groundwork really, really briefly. I think most people know this. But we do have an agreed upon settlement here for this class action lawsuit that has several different aspects to it. One of them is this $2.75 billion of back damages that are to be paid to former D1 athletes. That was one of the big headlines. Obviously, you're talking mega dollars there with that. But then the focus of this episode really is going to be kind of another portion of the proposed settlement. And that is this whole revenue sharing model. What does that look like for the NCAA, the schools, the athletes moving forward? Of course, right now, this settlement still needs approval by the judge. And that's going to be a little bit of maybe my first questions before we dive into the revenue sharing piece for Kevin. The judge does need to finalize this. So I guess my first two questions here, Kevin, both, kind of what were your initial thoughts when you actually, this came out in the press and the headlines in terms of just the settlement overall? And then also I'd like to hear, what is your expectations of interveners moving forward? We do know, I believe we have one right now, the Houston Christian university or school or something that has already said they want to be an intervener. I would expect we're going to see a lot more of that moving forward, both from schools and probably athletes. So I'm going to hit you right out of the gate with a twofold question here, kind of your initial reaction and also the intervener piece.
Yeah, and I'll give my usual disclaimer. We are trying to read tea leaves here. So as long as everybody understands that we're all just giving our best guess here. I wasn't that surprised to see the settlement because, and it's actually not just House, it's actually a couple other lawsuits that are hanging out there. Not to get into legal mumbo jumbo, but it's accusing the NCAA of various antitrust violations. And the NCAA had to settle. They had to come to some kind of financial agreement. And so the numbers are big. But it also, even though the parties have agreed, when anytime you settle a class action, you also need the court to agree. And so the judge is eventually going to have a hearing, and the judge is going to determine, hey, is this fair? Is this a reasonable settlement? And yeah, we already saw one intervener. It's an FCS school. I believe it's where Bailey Zappi went to college, but it's a school that says, hey, we were left out of this discussion. So, hey, judge, you can't say that this is fair and reasonable because we really didn't have a seat at the table. And what tends to happen in these things is the people who do have the seat at the table are the big schools, right? The FBS schools with the big money and the big conferences and the big TV deals. And at least in the Houston case, they've said, hey, you cannot go forward, court, because this didn't consider our view. And if we're going to be responsible for paying some of this settlement and sharing some of this selling some of this revenue, we need to have a seat at the table. And, a judge might say, hey, look, we can't give everybody a seat at the table. The judge might say, you know what, the NCAA did their best and both parties have agreed. And if they agree, unless it's, unreasonable, I'm just going to allow it. So I think we're reading the tea leaves a little bit, but I would expect that the settlement will ultimately be approved. And then, the schools are going to have to sit down and figure out how are they going to disperse this money to all their athletes. This kind of side issue that's hanging out there is Title IX. And so if we're distributing some of this money, do we have to do it fairly between men and female athletes and male athletes? Nobody really knows the answer to that. So it's going to be a lot of devil in the details where college administrators are going to sit down and have to think long and hard, like, how do I disperse this money? How do I settle a legal claim and avoid getting another legal claim by, let's say, the women's volleyball team who feels like they were shut out at the revenue sharing? So it's not an enviable position for colleges, other than they're getting a settlement and they know the litigation is going away. The hard part, the devil in the details, as I said, is really going to be, okay, how do we divvy up this money and how do we do it kind of in a fair and equitable way to make everybody happy, or the least amount of people unhappy? And that's going to be tricky.
Yeah, and you brought up Title IX. That's going to be the next section I do want to get to.
Yeah.
But I know Steve and I have talked kind of right after this settlement came out. There was some headlines mainly coming out of the Big East and some of those basketball heavy conferences and schools that, to your point, didn't really have a seat at the table. And the way the NCAA has, going down a little bit of a detailed path here, but I think it's important because it talks about what you were saying there. That they didn't have a seat at the table, yet they're using basketball revenue to kind of divvy all of this up. Steve, do you remember the university president that was really kind of the spokesperson on all that? I'm drawing a blank.
It may have been UConn. I can't remember. Really, the Big East commissioner specifically, because I think the Big East is that unique case where basically all of their revenue is basketball driven.
Yeah.
Whereas in most of this NIL money was football driven, but they're having to pay all this money. So I can't remember the exact, but I know a lot of the Big East presidents and the Big East commissioner was upset.
Yeah. Yeah. And there's no matter what, somebody's going to be upset, of course. Even if they did it a different way, then somebody else was left off the table and all that. And that's, to your point, that's kind of why a federal judge has to say, did they, was everybody heard to the degree that they could? Is it fair, if that's a word that you can use?
Yep. Fair and reasonable. Yep.
Yeah, reasonable. But we did talk about that. I mean, you've heard a lot of, or some schools really kind of upset about how they determine these back payments are going to be paid. So let's go to Title IX, because you brought that up. This was something I always bring Title IX up, and Steve always says, JY, it's not that big of an issue. But maybe I'm overstating that with him. But and so and you touched on this a little bit, Kevin. But how do you feel this may proceed? So with the Title IX issues, obviously there has to be equality and fairness to this. And you're hearing different takes. Kind of the one take is kind of just this prorationate share across the board. X number of students equals X number of dollars. It's maybe the easier way to do it. And I've also read maybe the most conservative-ish way to do it. But then there's also this other thinking where it's like, well, no, we should really be able to drive more revenue to the revenue producing sports. That doesn't mean the others don't get anything, but you're going to weight it differently depending on where this revenue is coming from. Do you have any opinions on which one of those can be done, should be done? Do you think schools are going to end up doing this differently, perhaps, or do you think we're going to be able to kind of coalesce around one correct structure?
I think everybody's going to kind of do it their own way, and lawyers like college counsel are probably going to be very intimately involved with their college administrators. So I think both formulas they mentioned have some merit, kind of a formula base, because when it's a formula, you can just say, hey, this is the formula. We just applied it mechanically and evenly. But that kind of ignores some of the relevant factors about, well, you can't really do this in a vacuum. You almost have to consider, if you're giving revenue and you're sharing it, where did the revenue come from, right? It's the whole NBA versus WNBA. Yeah, I'd like them to fly charter too, but they don't generate enough of the revenue. So it's we're not really a charity, although the NCAA sometimes view themselves truly as a nonprofit, but we have to consider these other factors. So I think you're probably going to see schools use some element of both of them. And again, they have to keep in mind that what they do for the men, they have to, if not equal, they have to do something fair to the women as well. And that's going to be the tough balancing act. And again, they're going to be settling this lawsuit. I wouldn't be surprised to see complaints filed by certain women's teams that may feel they were not treated fairly in the settlement, and they'll bring their own action. So ironically, you're settling one action and you're creating another, but that's kind of the modern NCAA and college athletics.
Yeah.
I have a follow-up question to that. That kind of goes together with the first question and a little bit of Title IX. So when I look at this settlement, I look at it as, okay, we're trying to settle past damages, damages that were done to previous players. They were not able to receive NIL. And that's part of it. That's basically the nuts and bolts of the settlement. However, it seems as if, and you can tell me if I'm reading the tea leaves wrong, it seems as if the NCAA and the major power conferences are also trying to use this as kind of to establish a structure moving forward. So kind of going into the first question that JY asked, do you see this? So do you see the judge having a problem with that? Because obviously he wants to take care of the damages to the current and previous players. But do you see any kind of roadblocks? And I know JY is going to get into asking you about some legislative things and stuff. So not really getting into that, but just this decision. Do you see this as just taking care of past damages, or do you see this as setting precedent, I guess is a good word, of a path forward?
Yeah, I think the judge is solely going to be concerned with this settlement, but I think as part of this settlement and part of how schools divvy it up, that's going to become kind of the roadmap for how things move going forward. And, cynically, I would say this is probably something the NCAA should have done, I don't know, pick 10, 15 years ago, probably to avoid all this. But instead, they kind of hung on, tooth and nail to this concept of amateurism, and we can't play athletes and it would destroy college athletics. Well, now you're in a situation like this. So I think the judge is just going to be really concerned with, is this settlement fair and does it remedy all the past damages? But then schools are going to use this for the model going forward. And I should say, with all this money going out, reading the tea leaves again, I see probably we're going to see some college athletic departments have to trim payroll because they're probably some bloated, and those numbers are going to have to come from somewhere. And then the other flip side is they're going to look to other areas to generate revenue. So I'm already starting to see about, logos on uniforms, logos on the field. Some conferences, some teams looking into private equity. So literally having private funding. I know Florida State looked into that about a month ago, which is, again, to bring private investment in to say, hey, we're a great investment, put your money in us. So I think, the landscape is really going to change over the next couple of years as we see the settlement carried out and divvied up. And then what does the future look like? And how does the schools kind of make up for all the amount that they're paying out as part of the settlement? You got to make it up somewhere. So is it on the field? Is it on uniforms? Is it, all these different aspects they're going to have to consider, reducing staff and all these type of things. They're going to be basically running a pro sports franchise, for better or for worse, is going to be the model.
Yeah, and to get back to the Title IX real quick, I know it's and I deal with this. I have to deal with this with my everyday job. I work, but it's about opportunity, and that sounds easy. Like they have to be given the same opportunities, and okay, that makes sense. They so say, okay, well, they both men and women in whatever sport they are, they have to be given the opportunity to be able to receive some sort of revenue sharing, right?
Yep.
But where I slip up with it, and where I get caught sometimes is when I say, well, it has to be even, right? Well, opportunity doesn't mean even necessarily, but I also feel like depending on how far you want to push that, that's where, maybe some more lawsuits come in, and you kind of mentioned that as well. So, when you go back to the conservativeness and just say, hey, it's dollars divided by students and boot, black and white, you're done. You go, okay, well, who's going to fight that?
Right.
Other than maybe the football players saying, well, wait a minute, the revenue, we're 90%, I'll just use silly numbers, but 90% of the revenue coming in, but we're only getting 25% of the revenue going out. How's that fair? And you go, okay, well then we'll do it the other way. We're going to make sure that, all the money comes in. We're going to give 90% to the football team because that's what they raise, and 10% is going to go to everybody else. And then I go, well, now you're going to have I would think female or anybody, but a female model. Well, why are they getting that? So I don't know if we have an answer to that yet, but I can see both sides of that equation, and I think it's going to be interesting to see how they define opportunity, and how gray can that get? Do you have any opinions on that, or am I overstating it a little too much?
I think those are exactly the debates. And again, the problem with this is if there are more lawsuits, we always think that a judge understands the issues as well as they do. Yeah. But they're just, I don't want to say they're just judges, but they're federal judges. They handle criminal cases, contract cases, other kind of real estate disputes. We can't expect them to understand the nuances of. I barely understand them. I've been working in it for 30 years. I mean, it's hard to expect a federal judge is going to understand and appreciate all these arguments. We can make them on blogs and podcasts, but, it's probably naive to expect federal judges are. So I think we're going to see a lot of more focusing on the fair, not so much the equal, but fair. And is it fair under the circumstances? And what does fair mean? Well, it's whatever the college is going to decide, or it's whatever a judge or a hearing officer is going to decide. And it's, and as much as it's going to settle up some disputes, it's going to lead to others, because there's no perfectly fair, there's certainly not an equal one. And it's going to be hard to get fairness all the time. And who, what one person thinks is fair as a football player, well, you can make everybody equally unhappy, and then you've solved none of your problems. So it's going to be interesting.
For sure. Let's talk about another topic that we really kind of focused most of our discussion on last time we had you on, and that's just NIL in general. But I want to, kind of tie in these collectives, which was kind of the reality here for a little while, because the schools weren't allowed to be involved. Well, now, everything's the complete opposite at this point. So how do you feel third-party NIL collectives are going to be affected by this, if at all? I mean, maybe they're not at all, but do you think this has any impact on what's already begun?
Yeah, I don't think they're going away anytime soon. I think there's still going to be a viable vehicle for boosters to give their money and have it distributed to the players or the teams that they want. So, I think the collectives will have probably again, in the past, it was kind of the schools had to be hands off. Like the collective did that. We couldn't get involved in the deals. And I think we're seeing a path now where it's going to be permissible for the schools and the collectives to probably work closer together now. Whereas in the past, it was kind of this unusual relationship, kind of hands off. So, there is still a role for collectives. The departments are going to become more involved. And then from an individual player basis, there's still going to be a role for the top players to do their own individual deals as well. So, I think NIL as we see it now is going to continue. It'll be refined. It'll change, but the collectives are going to be alive and well, even post-house settlement for sure.
You kind of have this. I don't mean this to sound shady, but you have the on the books and then you have the off the books, right? The on the books is through the school and what everybody's allowed to have and yada, yada, yada. And then you have the off the books, or at least off the school's books, third-party collectives, and they can be the sky's the limit at this point and things like that, I believe. And I want to tie that to my next question here, and that's state legislation and how that may affect things moving forward. So, we have assuming this lawsuit or this settlement is approved, everybody's kind of has at the same starting point. But we've seen some states already get involved in this. And I mean, how do you view what that might happen moving forward when you have a state that says, hey, we're willing to go above this limit or even just make it unlimited? I mean, how does that play into all of this moving forward?
Yeah, it really reminds me of how we got to the NIL in the first place, is because the NCAA wasn't doing anything. And states like Florida and California started passing their own laws. Not right away. They said, hey, in 2 years, we're going to make this legal. And the NCAA still didn't act. It was only when, those deadlines were approaching, and then they had a Supreme Court decision on educational benefits, this kind of perfect storm where the NCAA said, okay, we're just, do whatever your state law says or do whatever your university says. So I think, the tough part, and people are calling for federal legislation. So obviously if there were federal legislation, then all the state legislation goes away because the federal legislation would generally prevail. I would say you can't get Congress to agree on even important societal issues right now. To think that they're going to sit down and pass some bill to determine NIL rights or whether students are employees is probably, a fairy tale, at least as we sit today. So, states could really upset the balance here. And I assume it would be some of those same states like Florida and Texas and California going to get involved in, because they almost view it as that gives them a competitive advantage.
Right.
That was the thought with NIL, is that, hey, if we allow our athletes to do it, then people are going to want to come to Florida, or they're going to want to come to California. And so, yeah, I think especially with federal legislation being unlikely, at least at this point, yeah, states are going to get involved and see how far they can push the envelope and how much of a competitive advantage they can get with their state laws. And now that just most states allow NIL now we're seeing at the high school level where some states still don't allow it for their high school athletes, and the high school athletes are moving to states that do. So yeah, we could see the states and their legislatures kind of playing an important and active role here for sure.
Interesting. Yeah.
Okay, Kevin, I have another follow-up question for you.
Sure.
This is a little bit of a hypothetical based on your answers from the last two questions.
Okay.
So if you don't like the hypothetical, you can just say, you know what, I don't like that hypothetical. I'm not going to answer it. But, so
I haven't been in a hypothetical I don't like, but okay.
All right, awesome. So let's say, okay, so we talked about possibly moving the collectives in-house, or becoming closer associated with the school. So I'm going to use Penn State as a hypothetical. You're based in Harrisburg, Pennsylvania. So, and I'm going to base this off a situation that I think it maybe was a San Diego State player out west. So let's say we got the number one. Let's say Penn State has the number one punter in the country, and they're considering, they have one more year of eligibility. They're considering entering the NFL draft. They come to you. They want you to represent them. But they're also considering maybe staying in college one more year because they're getting a pretty good deal from the collective. So, they want you to represent them. And again, this is hypothetical. So under the framework of this settlement, for some of the things that we've heard is that schools will use this framework as kind of a roadmap. So let's say, I think we've seen the number is $22 million per school, that they'll have to pay that as part of the settlement, but also that might be used as kind of a new salary cap per se going forward, that each school can pay $22 million. So you have a player you're representing in this hypothetical is thinking about going to college, or thinking about going to the NFL or
draft, turning pro.
Yep, turning pro or staying one more year. And let's say the market for a top punter, this is a little far-fetched because we're talking a punter here, but let's say the market is generally about $1 million for the top 5 punters in the country. And he's clearly that. He's number one punter last 2 years. He's got one more year of COVID eligibility. He can be a 6-year guy. And the school says, hey, we'd love now they have a little more control of the collective, and they say, hey, we'd love to give you $1 million, but we only have 22 million to work with, and we had to give player A this amount, player A this amount. We can only give you, 150 grand. So can you walk me through your thinking? Do you see a scenario where player agents, player representatives, contract lawyers start to get involved with those negotiations? And then also, do you see a scenario coming up where someone challenges that and says, there's no real limit. You can pay us whatever you want. Just again, I'm not trying to get you to solve all the NIL problems today. Just walk me through your thinking on that. How you might handle a situation like that, what you might tell a player.
Yeah, first of all, it's more than hypothetical because these discussions have happened. And I was in conversation with a player that I was recruiting last year who entered the portal, and he had a choice. He could enter the draft or he could move up to an FBS school. And sure enough, he got a lot of FBS offers, and the collective gave him money. And the decision point is really, what is your NFL draft status? Because if you're the top punter, other than, I think the Bears took a punter in the 3rd round, but let's assume you're a traditional punter, even though you're the best, you're only going to get drafted in the 6th or 7th round. There's a good and it's unlikely that maybe you make it, maybe you don't. In the case of a punter, obviously, if they take you in the 3rd round, you're going to make it. They draft you in the 6th or 7th, you're probably competing with a veteran. So the issue is, okay, which is the better deal? And so I think what we're seeing, like this year's draft coming up, is going to be very deep because so many players decided to stay. I know there's players at Penn State who were weighing that same decision, and the collective came along and said, well, I can give you X. And if, you know, I've talked to a few Penn State players who are in this predicament, and there was one defensive player who said, you know what, if I come out, I'm an undrafted free agent, which means maybe I get a small signing bonus. Yeah, maybe I make the league and I'm making 800 next year, but I can get 150,000, another year of education, and I'm only losing 1 year. So that's really the analysis. So the analysis is really a function of how high you're going to be drafted. What's the likelihood you're not, you know, it's great to be drafted. It's great to be signed undrafted, but are you going to be on the roster in September? Because if you're not, you know, chances are by staying in school, you're going to get more for NIL money than you will for your signing bonus or whatever you get, you know, whatever you earn in training camp. So that's really the discussion. And that's where the agent really has, the agents are always obligated to act in the best interest of their client. That's the way I approach it. It's not my selfish desire to, hey, I want to have him come out because I want to make 3% of his contract. It's what's the best for you. And a lot of these cases, especially for guys moving from FCS up to FBS, the draft is a crapshoot. I can't tell you what's going to happen. And even if you are drafted high, there's no guarantee you're going to make it. But if this team is, you're going to an FBS school, now you're going to be playing on national TV. You could elevate your draft stock. Oh, and they're also going to guarantee you 250,000. You know, and again, they can't do pay for play, so you still have to show up at the hospital, and you got to do a social media, and you got to sign autographs. But you know, you're supposed to get fair market value. But so those hypotheticals aren't really hypothetical. They happened a lot this past year, and they're going to continue to happen every year as the amount that a collective can pay to keep a 4th or 5th year senior is close to what they would make if they're drafted. And again, you want to go with the sure thing. And especially with a guy moving up levels, you're getting a better program, better exposure, you're getting paid, and it might actually elevate your draft stock. So that's kind of the analysis that the player and the agent, or the potential client and the agent, have to go through and make kind of the best decision. And that's where the collectives really can throw their money around, is to keep a guy who is thinking about turning pro. In the past, you had all these guys declaring, lots of them never got drafted, lots of them never made it. Now what you're seeing is this backlog of talent because collectives are keeping these guys in school for a 4th or 5th year, 6th year, some cases.
And that's something you actually said to me, Steve. I don't know if you had gotten it off an article or not, but it was, you actually may see more student athletes stay in school now because of this. You know, a lot of we don't know. I mean, I guess time will tell if that's the case, but we hear what you're saying here, Kevin, and it does sound like there's examples. There's probably examples on both sides, but you know, this may actually have the students staying in school longer because of exactly what you just said there, Kevin.
Yeah, and this year, NFL people told me, and we saw that the back end of the draft was not as deep because so many guys stayed in school. The flip side of that is the 2025 draft coming this April is going to be very deep, and that makes it tough. There may be guys who are juniors thinking about it coming out, you know, after this year, and they're going to look at it and say, "Wow, this is a deep draft. My collective is offering me 250 to stay, get another year of college, another year of strength and conditioning.
Yeah,
you know, I'm still going to be 22, 23 when I come out. Why not take this guaranteed money? I invest that and I keep that aside, and maybe I raise my draft stock." So I think we saw a lot of NFL people dismayed at the talent pool, for lack of a better word, that existed because so many guys were convinced to stay in school because of the collectives. So,
okay.
And overall, that's good for players if they have more options. It's not really competition, you know, especially for the top talent, but more opportunities for players, more choices for them.
Correct. Yeah, and you know, the thought that it was going to destroy college football, destroy the locker room. You know, honestly, I'm just not seeing it. I'm seeing the opposite. I've seen a lot of schools like Penn State where the rising tide lifts all boats, where they're, you know, all the players are benefiting and they're all making money and they're all helping each other out. And so Nick Singleton does an autograph appearance, but he brings the backup lineman who normally wouldn't get that opportunity. So I think rather than dividing locker rooms, I think it's actually helped, you know, as a whole. And again, kept players in school, because those players who declared and never got drafted, now what are they going to do for the rest of their life? They don't have a degree. They're not in the NFL. Whereas if they stay in school, at least they have, you know, some nest egg they have $100,000 or $150 that they could at least get started on their next career. So.
No doubt about that. So the last thing I want to talk about, Kevin, is, you know, this belief that this settlement potentially strengthens the fact or the argument that athletes are actually employees. So we're kind of taking maybe a step aside from the settlement, but that's kind of some of what I'm hearing, I'm seeing online, is that, hey, this settlement's actually Just another chink in the armor, if you want to call it that, of, hey, these athletes are employees, and that's ultimately where we're really going to be heading. Do you agree with that, disagree with that, and maybe why?
Yeah, I think that issue is still percolating. We have a case, I think it's USC's football team. We had Dartmouth's basketball team trying to unionize and say they're employees. Yeah, this gets us closer to employees, because if you think about the factual reality of what college sports is like, the school is pretty much your employer and the athletes are pretty much their employee, right? Because they have policy manuals. They're told where to go, when to go, where to eat, how much to eat. I mean, so that's basically the employer. When somebody is controlling how you do your job and when you do your job, that basically makes you an employee. So, yeah, I think this is getting us closer and closer to employee status. The only thing that could fix that, again, to get back to our prior discussion, is probably federal legislation. I know a lot of athletes think, hey, it'd be much better for employees, because if we're better, we could, if we are employees, we can collectively bargain and negotiate all these things. I think what people don't realize, or maybe don't think about as much, is if you're an employee, that means you could be fired as well, right? So we could see teams take an approach where, okay, I have 10 employees or 12 employees or 15 employees on my basketball team. Well, I'm going to churn the bottom of my roster. So, thanks for being my employee as a freshman, but now I'm replacing you with another freshman and you've been fired from your job. So while there are a lot of potential benefits that could come from employment, and clearly it looks like an employer-employee relationship, there's all these kind of hidden dangers of, okay, you get in trouble, you could be terminated. You don't play well, you could be terminated. So, as there are some benefits to being employees and being deemed employees, but there's some risks for players as well.
Kevin, I got another follow-up for you here. I love follow-ups. Sure. Okay.
All right.
All right. So I've heard this notion that basically there's some players who, obviously we've seen the Dartmouth basketball team, an Ivy League school. Some players definitely want to be employees. I've heard directly from some contacts at Penn State, there's a lot of players that don't want to be employees. They want some financial benefits, but they don't want some of the restrictions that would come with employment status. And I just want to throw this out here. We've talked about there may be a scenario where, in a state of California, and the NLRB, those are private institutions. So they may be ruled employees, where in a state of Illinois, something else could happen. And then, in Pennsylvania here, there are specific rules about public employees. I'm a public employee. Well, we're both public employees. So we understand some of those rules about public employees and some of the restrictions on collective what can you collective bargain for, and different things like that. So you, as someone, you are kind of you're right in this world, you are working with players. Do you see, is there a consensus from what players want, or do you think it's just kind of mixed for those reasons?
Yeah, I think I don't think there is a solid answer. I think I understand why, like, Ivy League basketball players felt like it was beneficial to be employees, and maybe some football teams do. But I think most players, I shouldn't say employees, most players are going to do better in a non-employee type situation. I think it's just an attempt to get leverage, really, and it's an attempt to get leverage in the relationship. But again, as I mentioned, there's risks to being an employee. First of all, you only have to pay an employee, depending on your state, about $7-8 an hour. So they could have minimum wage, and overtime issues. And it could, as good as it sounds, there's a lot of risks that come with it. But I think we are facing the possibility that, with private universities in Dartmouth and in California, they are employees, whereas in other states or public universities, they're not. And, it would be a hodgepodge, which is, I think people want to avoid, it being a different answer depending on what state you're in. So I think if you ask most athletes, they probably don't want to be employees. They want to be able to play their sport, make as much money as they can, and kind of be able to pursue a pro career or do something else, but earn and maximize, the revenue that they can from their name, image, likeness, while they are a student athlete, and recognizing that there's a little different than a traditional employer-employee relationship. And they'd be better served just by being athletes and making as much as they can and playing their sport, period.
Awesome. Well, I have one last question. It's the most important question, Kevin.
Got it.
Remind our viewers where they can find you on X, LinkedIn, wherever that may be. Remind everybody where they can find your info.
Yeah, so I am on Twitter or X it's at longsnapcom. And if you want my website, it's longsnap.com. Most of my NFL clients are long snappers. So if you didn't get enough out of this discussion and you say, hey, I want to learn more about NFL, college, and high school long snappers, you can go to my website at longsnap.com too.
Awesome. And we'll be sure to put Kevin's information in the description here as well. We want to thank you, Kevin, for your time you spent with us here in the Big Mountain.
Thanks for having me.
Second go around here again. And I have a funny feeling if you're willing, we'll probably like to have you back in the future.
Yeah.
I'll be back. We'll see if any of these things I said are right. I may look like a fool 2 years from now, but we'll see.
Hey, it's always interesting. I mean, we like to pick apart some of these things and just try to figure out where we are today. I mean, tomorrow is hard enough. We're just, where are we at today? So,
right.
Anyway, hey, thanks a lot, Kevin. And for our viewers, hey, make sure you give this one a like, subscribe if you like our content, and we'll see you guys next time on the Big Mountain.